All right, this is case number 2012474 FH, People versus Dallas John Roney. Mr. Greer is appearing here on behalf of Mr. Roney. They had filed a motion to reconsider the bond that was set. The court had previously revoked and forfeited the bond that was set in this case, and set a new bond at $25,000 cash or surety. There was some indication that Mr. Roney was perhaps lodged in St. Clair jail, and Mr. Stay, that you received information that on the date of his original pretrial that he missed, which would have been October 20th, 2020, that he was not lodged in jail in St. Clair. Is that correct?
My staff did contact the St. Clair County Jail on May 21st, specifically about this question, and they indicated that he was booked on October 25th and released on March 23rd, 2021. So according to their records, he was not in jail at the time. Their jail.
All right. Well, and then the jail here in Nuevo County has indicated that he posted bond on this case on the May 22nd. I don't have any documents in my file indicating that who posted the bond or what. Basically no documents from the jail at all, but he's out of jail. We checked twice and he's not in jail. So Mr. Greer, given the fact that he was able to post the bond, apparently, are you withdrawing your motion?
I am, Your Honor. However, if I may, my notes indicate that Mr. Roney was lodged or in jail on 10/16. So I assumed it was St. Clair County because that's who held him, but it may have been another county and then they went and got him. But according to what Mr. Roney had said to me, he has been in jail since 10/16 of 2020. And our hearing, the pretrial where the bond was canceled, was on 10/20. And on the 18th of October, I tried to get a hold of him throughout that period of time until the 20th at the hearing. And I got I just was getting voicemails. And so I think he was in a jail. I'll have to find out where when I get a hold of him.
I guess, Your Honor, to give it a little more clarity, I did look at his criminal record again. And unless they decided to bring this charge later, it does show an October 25th, 2020 arrest for driving on a license suspended and possession of methamphetamine in St. Clair County. It would obviously make more sense that he was arrested that day because he was out. Now, could that have been the charge brought later? That doesn't seem likely. So to me, it seems like he was not in any jail on the date of our pretrial, but I may be wrong.
Your Honor, if I may respond, my client up until this time had always been available for Zoom hearings. And that's why I was suspicious that he might be lodged somewhere, because on the 18th, I couldn't get a hold of him. I could get a hold of him up until then. And when we had him in district court, he was always available and I talked to him on the phone. And so then all of a sudden I can't get a hold of him. It just let me to believe that he may, one or two things, either absconded or he was lodged. And so he told me 10/16. I don't know. I have no idea. Mr. Stay's information, what his explanation certainly makes sense. I don't know. As soon as I get a hold of Dallas, I'll find out, Your Honor.
All right. Well, at this point, the motion to reconsider the bond is denied. He's apparently posted it.
Very well.
Whether it was revoked, forfeited, or if a judgment was entered on that bond, well, he's obviously been rearrested since then, so the surety company shouldn't be out any money. But I guess if we ever see Mr. Roney again, we can try and sort it all out. So
Very well.
motion is-
Thank you, Your Honor.
Thank you, Mr. Greer. You're also on Mr. Hodges, is that correct?
I am, Your Honor.
All right, we'll next take up the case of People of the State of Michigan versus Antoine Alexander Hodges. It's case number 2012644. FH, Mr. Hodges is appearing by Zoom from the Vallejo County Jail. Can you hear me okay, Mr. Hodges?
Yes, sir.
All right. And this is Mr. Greer's motion for release on a personal recognizance bond. You can go ahead, Mr. Greer.
Thank you, Your Honor. As I point out in my motion, the defendant was arrested on December 16th, 2020. I believe we have a pretrial scheduled in this matter on, I thought it was June 28th. Let me check. But up until today, Your Honor, he has served 164 days. And up until the end of that would be obviously approaching the 180 days. Hang on, let me. I didn't put. He has a pretrial, I think, coming up in June. But in any case, he is quickly approaching the 180 days. And I would ask the court, the bond right now is set at 20,000, I think 20,000, 10%. I would ask for a personal recognizance bond, Your Honor. I have not had any criminal conviction since 2005. He lives in Grand Rapids. He's established in Grand Rapids, Michigan, and I would ask the court for consideration.
All right, thank you, Mr. Greer. Ms. Robinson?
Your Honor, I believe that the dates and the information laid out in my brief, or excuse me, it wasn't a brief, I believe. No, it was. I did file a brief in response. And that made clear my argument that certain time periods involved in that calculation pursuant to the court rule should not be included. They should be excluded in the calculation of those 180 days. instead of reciting what the court has in my filing, I will just rest on that unless, of course, the court has questions that I'm happy to elaborate on if there was any uncertainty. Thank you, Your Honor.
All right, thank you. So in this case, I guess there's a factual dispute. Prosecutor indicates that Mr. Hodges was arrested on December 12th. Mr. Greer, in his paperwork indicated it was the December 16th. But the Register of Actions is clear that that the defendant waived the 21-day rule for the preliminary examination. That resulted in a 10-day delay in the proceedings. The case was then set for April 6th. The defense requested an adjournment from April 6th to file a supplemental brief. The supplemental brief was filed on May 12th. And that deals with a motion to suppress in this case. On top of the 10 days, I would find that the delay attributable to the defense would be 36 days. That gets us up to the filing of the supplemental brief. Once he filed the supplemental brief, the prosecution has an opportunity to respond, and then we have to get it on the court docket. So between their response and getting on the court docket, the court would find that there would be another 30 days that would be attributable to the defense.
Your Honor.
Yeah.
Your Honor, we waived the 21 days because we didn't have all the evidence from the prosecutor. We needed to get the tape of David Israel, and so which we still didn't have by then, and we ran it anyway. With respect to the motion in April, I was on medical leave. I filed my motion, and for some reason, Mr. Krysak felt we needed more information. I thought that we had plenty of information in that original motion, and but be that as it may, none of that is Mr. Hodges' fault.
The court rule reads attributable to the defense or the defense attorney. And I'm not saying.
Go ahead. I'm sorry.
You had your medical situation. We totally understand that.
I appreciate that.
Now, because of the court schedule, we can't get him back on to the docket until July. But I didn't count the whole time from then. So the court is going to find that there's 76 days that are attributable to the defense or consented to by the defense. And from the 164, so from my calculations right now, as far as the 180-day rule, we're looking at, we're sitting at 88 days that are totaling on that. So we have not, even under the straight amount of time that's been served, we haven't violated the 180-day rule. There are times that's attributable to the defense. And certainly as we approach 180 days, the court would be willing to look at the bond again in a new light. This case, the recommendation, at least the last I saw, was for a prison sentence. And this is a habitual offender third with priors alleged to be armed robbery, 2 counts of armed robbery. This is receiving concealed stolen property and possession of ammunition by a felon. These are serious charges, but I'm not getting to whether he poses a threat to the community, whether that he's likely to not appear, because due to the calculation of the time, we're not even to that point yet. But the court does recognize that Mr. Hodges is in jail, and we'll do everything we can to expedite the motion hearing that's set and any trial coming forward. And on the facts of the case, we can look at bond any time, but we have not run afoul of the speed trial.
Your Honor, would the court
Yes, sir.
consider reducing the bond to a more reasonable amount? As I indicated, the felonies that he committed, he did his time for. He's off of parole, and the charge that he has now is a non-violent charge where we have a defense, plus we have a motion pending to challenge a search where, you know, I don't file motions frivolously. And so Mr. Hodges has been a model inmate. His family has been all the time contacting me. His uncle, who is a well-respected doctor in the Grand Rapids community, and his mother, who is a well-respected citizen of Grand Rapids, where he's living. I would ask the court to at least consider reducing the bond. Mr. Hodges is not going anywhere, Your Honor. He has every intention of defending these charges.
Any response, Ms. Robinson?
Your Honor, we would object to any change in the bond at this time. As the court has already decided, we are not at the 180-day PR point that would occur pursuant to MCR 6.004. In addition, this is an individual who is charged currently with 2 felonies, who has a felony record, who's familiar with the system, who has been through this before, and who is still facing new charges. As such, we don't believe that there's anything unreasonable about Mr. Hodges' bond, and we would ask that the court leave it as it is currently set. Thank you.
Well, so the bond that's currently set is $20,000, 10% cash or surety. So for $2,000, Mr. Hodges could get out. For $500 to a bondsman with some collateral, he could get out of jail. So I don't find that that's an exceptionally high bond in this case. He does have prior felonies. I don't know what else he has, if anything, on his criminal record other than what's been listed in the habitual offender notice of this case. I don't know if he does have anything else, but Mr. Hodges, with these well-respected family members and so forth, they don't trust you enough to put up $2,000 to bond you out.
If I had to, I'm responsible for my own bond, so I don't have the money.
Okay, all right. Well, I'm going to leave the bond as is. The court can certainly revisit that if I learn more information through the motion hearing process. I don't want to have Mr. Hodges be in jail any day longer than need be. If he's got a valid defense or he's got a valid motion to suppress in this case. But we're not at that point yet, so motion's denied.
Your Honor, I apologize. The motion that Mr. Greer has set is currently noticed for August 3rd. Would the court move that up if we filed our response quicker? Because I may be able to make that happen.
Yeah.
Thank you very much. I very much appreciate that, Ms. Robinson.
I know how backed up this court and most courts in the state are right now, so I just wanted to ask.
It's not only that response, but I'd have to find half a day or at least 2 hours to hear it. So if I can do it, I can move it up. There's no problem with that. I just have to find the time.
Your Honor,
Yes, sir.
I don't believe the court, Ms. Robinson and myself have talked about this. The evidence has already been testified to at the preliminary examination. Basically, all the court would need to do is review the body camera of the officer as well as the preliminary transcript of that same officer. And I believe we can narrow that down substantially. So I don't, in asking the court to move it forward, I don't believe we're going to need very much court time other than Your Honor's time in his office to review those items.
All right, well, we'll take a look at that and we'll make it happen as soon as practical.
Thank you, Your Honor.
That's all for today. Thanks.
Antoine, I'll be down to see you.
Okay.